Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing immigrant spouse visas, specifically the IR-1 and CR-1 category. For those unaware, IR-1 refers to immigrant, immediate relative immigrant spouse, or conditional resident, which also pertains to an immigrant spouse. The difference here comes down to how long the given couple has been married at the time of entry to the United States. The immigrant spouse visas, both the CR-1 and the IR-1, confer immigrant status upon entry in the United States and issuance of what's called an I-551 stamp therein. That being said, more to the point with respect to this video, we're talking about pregnancy. This comes up a couple of times a year. I'll get an email from a client. Basically, we're usually midway through the processing of their marriage visa case, and I get an email that says, hey, guess what? My wife's pregnant. In most of these cases, we're dealing with a foreign female and an American male, generally speaking, and the foreign female has become pregnant during the processing of the case or sometimes immediately prior to the petition being filed. My immediate response to that is I think, fairly normal. Congratulations, that's great. You're adding to your family. That being said, the ramifications from that with respect to the immigration implications are twofold, or I should say somewhat bifurcated in a way. There's kind of a dichotomy associated here. One, on the factual side, it only goes to bolster sort of the bona fides of a given relationship. If you've become pregnant or happen to have a child during the course of the processing of a given visa case, that only goes to show that obviously the marriage is that much more bona fide. I shouldn't even say that much more bona fide. It just is one more piece of evidence in favor of the bona fides of the given relationship. Further, it should be noted the existence of a pregnancy or even a subsequent American citizen child born abroad to this foreign spouse really has no bearing with respect to legal grounds of inadmissibility in a given case. And I often see situations where we have legal grounds of inadmissibility, waivable grounds oftentimes, where I'll basically have the American spouse say to me, well, she's had an American citizen child. Doesn't that factor in to findings on legal grounds of inadmissibility? In point of fact, no. The adjudication by consular officers at a U.S. embassy or consulate abroad, they're looking at that immigrant or proposed immigrant specifically. It's irrelevant whether that person is pregnant. It's irrelevant whether that person has had a child. They're simply looking at that person's history and whether or not they're eligible as a visa applicant to receive a visa to the United States. So if there's like a prior criminal history involved in the underlying facts of that given case, the fact that there's a pregnancy or subsequently a born child associated with that marriage, that will not have anything to do with mitigating those legal grounds of inadmissibility in and of itself. It might go evidentiarily toward a later waiver or something, but even that's a totally different issue. The thing to take away from this video is pregnancy or a child, yes, it helps from helps is the wrong word, but it's one more piece of evidence to support the bona fides factually of a given marriage, but it doesn't have anything to do with findings of legal grounds of inadmissibility by a consular officer at a U.S. consulate or embassy outside the United States.